Good morning. I'm going to call to order this meeting, a regular meeting of the Zoning and Planning Committee for Thursday, October 11th. My name is Jeremy Schrader, and I'm the chair of this committee. With me at the dais are Council President Bender, Councilmember Reich, and Councilmember Gordon. Let the record reflect that we have a quorum. We have 4 items on today's agenda, and we'll begin with the consent agenda, which is item number 2 through 4. Number 2 is the passage of an ordinance amending regulations for lots containing 2 or more zoning classifications. Number 3 is the passage of an ordinance amending the definition of a limited entertainment and regulations related to general and limited entertainment. And number 4 is the passage of an ordinance amending the regulations related to rooftop mechanical equipment, penthouses, and building height. Are there any questions or comments from committee members on these items, or would any like to pull anything off for discussion? With that, I'm going to move item 2 through 4. All those in favor say aye. Aye. All those opposed say no. The ayes have it, and the motion carries. We'll now move on to number 1, which is the consideration of the Certificate of Appropriateness and Historic Variance Appeal regarding 424 Washington Avenue North. This item was continued until today at our last committee hearing at the request of the applicant. Before I open the hearing, I will ask the staff for a presentation.
Good morning. The subject property is located at 424 Washington Avenue North. It is located in the Minneapolis Warehouse Historic District. The applicants requested a certificate of appropriateness to allow for access to an underground parking garage off of 5th Avenue North on this side of the building, including some alterations to the existing loading dock, and then a new reorientation of the stairs and a new guardrail around it. In addition to the certificate of appropriateness, the applicant also asked for a historic variance to narrow that driveway width that you can see pictured here from the zoning code requirement, which is 12 feet, down to 9 feet 10 inches. At its meeting in September, on August 21st, the Heritage Preservation Commission adopted staff findings and denied both of these applications. Essentially, the issues are as follows. The applicant would be removing portions of this historic loading dock to allow for the access, even narrowed down to 9 feet 10 inches. Historic loading docks are an integral part of the Minneapolis Warehouse Historic District, and any alteration to that staff found to be inconsistent with the district guidelines, and we recommended denial. Additionally, that historic variance to narrow driveway width from 12 feet down to 9 feet 10 inches is just too narrow. We would see driveways sometimes for residential, maybe single family, down to 10 feet. But in this case, this would be even narrower than that. So staff really found that the applicant's request should not be granted. So in 2017, they were approved for a certificate of appropriateness to access the underground parking garage off of Washington Avenue North. That application came to this committee, and we upheld the certificate of appropriateness at that time. From this aerial, you can see that the access would be over a shared access easement that is held with the adjacent property owners at Security Warehouse and 5th Avenue Lofts. There is some disagreement about whether or not that should be allowed, and so the applicant is really before you with a second different request to move the access off of 5th Avenue North. And as previously mentioned, staff did not feel that that was an appropriate location, consistent with the historic guidelines, inconsistent really with the spirit and intent to allow a driveway width that would allow for sufficient area to maneuver vehicles, and the Preservation Commission upheld that. So the applicant on August 31st appealed their decision. It was continued from the previous Zoning and Planning Committee to today, and I would be happy to answer any questions.
Thank you. Councilmember Goodman.
Thank you, Mr. Chair. I'm perhaps confused because I was here for the last iteration of this. So we did allow them to put in a garage on this side, correct?
That is correct.
and they haven't done that.
They have not done that. I will leave it up to the applicant and the adjacent property owner maybe to talk about the current status, but I understand there's some litigation involved in whether or not that shared access easement would allow for the underground parking garage to be accessed off of Washington
So now
Avenue
they're coming
North.
back with a different iteration to avoid that problem with the neighbors.
That is correct.
Okay, got it. Thanks.
Thanks. Are there any other questions for staff? All right.
Thanks very
Jen.
much.
At this point, I'm going to reopen the hearing, and I'll first give the applicant the opportunity to speak to the committee. Is there someone here from there? Well, thanks so much.
Good morning, Justin Weinberg on behalf of the applicant. First, Councilmember Goodman, you are correct. This was here last year, and this is the reasons that we're moving it are precisely to address the neighbor concerns. So we've decided to reorientate it onto a different location on the building to address those concerns and not use that shared access easement for the purposes of the garage. The denial in reading through the report really focuses on the alteration to this loading dock. And so what we submitted in our statement of appeal, we really focused heavily on that because a number of the other criteria are actually met relative to the certificate of appropriateness. We also included a couple of exhibits, and principally what's mainly important are exhibits number 2 and number 3 that are included in the packet. With respect to the loading dock, we don't disagree that the design guidelines for the warehouse district state that preserving existing loading docks is critical. We agree with that. But what it really focuses on is preserving existing loading docks from the period of significance. And in this particular instance, the period of significance is the portion that we're actually stating that we should alter are well outside the period of significance. Here, the portion that we're altering, which is actually only 8% of the total loading dock square footage, was actually added in 1998. And the plans for that are included as exhibit number 3. So the 8% of the total loading dock that we're actually proposing to alter was that new portion that was added in 1998. We state in our statement of appeal that really that's a faux loading dock for the purposes of historical guidelines. It wasn't created during the period of significance, and we're not proposing to alter any portion of that. With that, we do believe that the alteration is in fact consistent, and it's consistent with what's been happening in the warehouse district itself. Exhibit number 2 are a number of photographs showing alterations to existing loading docks. And in fact, the very first one are our neighbors. And if we note those loading docks, there are new stairs added to it. There's looks to be a new retaining wall and a guardrail added to that loading dock. So to state that any alterations to loading docks are just per se prohibited is not entirely accurate, nor is it consistent with the actions of the city with respect to a number of other loading docks that are in the area. The report in HPC found that the removal and of the infill of the loading dock and the addition of the concrete stairs was not consistent with the guidelines. Again, for the reasons that the alterations are well outside the period of significance, and it's really only 8%. We do think it is within the guidelines. There was a recommendation that the new stairs be orientated so that they would be accessed off the Freight Street, which is actually a vacated alleyway. The applicant would agree with that recommendation and would follow that. There's also a recommendation that the applicant provide a horizontal metal guardrail consistent with the proposed guardrail, and again, the applicant would agree with that recommendation. The report goes on to make a conclusory statement that the project is inconsistent with the Secretary of Interior standards for treatment. Again, to support this, they cite to the loading dock. I don't want to repeat myself, but again, we're only altering that portion outside, and the loading dock itself, 92% of it is in fact being preserved. So we're not altering it in any way to affect the period of significance or the main element of that loading dock on this particular building. With respect to the historic variance, and I went back to the report, what the report and what the HPC adopted was that the alteration, which would actually go down to 6 feet, 8.5 inches, would be insufficient. And they based that on the fact that we couldn't alter the loading dock. But if the loading dock, that new one from 1998, is in fact allowed to be altered, we would in fact have a 9-foot, 10-inch width driveway. The report did not find that that was inconsistent or should be denied. The report focused solely on the smaller one, which is the 6-foot, 8.5-inch width. The 9-foot, 10-inch width is sufficient to allow a car to pass. This is going to be a single-lane entry. It's not going to be a dual-lane entry, and it is wide enough to, in fact, allow for that single vehicle to enter or exit in the drive lane. So we find that the historical variance or the denial, there was no finding that the 9-foot, 10-inch wide driveway would, in fact, be insufficient to allow passage. In addition, the practical difficulties that are being alleviated is in fact the small portion here of the building that we have to deal with. And these were not created by the applicant. One, we're not proposing to alter any portion of the loading dock from the period of significance. If we were allowed to do that, then of course we could meet a 12-foot drive lane, but we want to stay consistent with the historical design guidelines. In addition, there is a vacated alleyway that is causing part of the problem as well, and creates those practical difficulties. Again, that was not created by the applicant. When the city vacated that alleyway, it created this this alleyway that in fact is shared between the two neighbors. So we don't want to encroach onto either A, our neighbor's property, or B, on a shared reciprocal easement that exists in that vacated alleyway between the two property owners. So we do believe we meet the variance guidelines as well, in that the certificate of appropriateness should be granted and that the historical variance should also be granted. Any questions?
Thank you. Are there any questions from council members? Not seeing, I do have one. So you did talk about the alley width, and you talked about how one vehicle will be able to go through, and you alluded to a car. I mean, the staff in their presentation talked about meeting a 12-foot. This wouldn't do that. This would only make a 9-foot, 10 inches. Is that correct?
That is correct. That is correct. That's why the variance is necessary. If we could, we don't want to take out the loading dock from the period of significance, and that's why we can only have a 9-foot, 10-inch drive lane. But that is sufficient, and it's in our initial materials from our architect to allow passage of a vehicle.
Well, sufficient for what would be my question? I mean, is this for loading bigger trucks or just a single vehicle? Can you open the car doors? You know?
Sure. Single vehicle to allow entry from the public right-of-way to the parking garage underneath. That's the purpose of it.
Okay.
Of that drive lane.
Great. Thank you. All right. Not seeing any other questions. I'm going to now open the hearing. Thank you. To the public. Please limit comments to 2 minutes per person, which will be tracked at the timer near the clerk. Would any members of the public be interested in speaking? Thanks, and just come up and say your name and address for the record, please.
Good morning. I'm Lee Dean. I'm president of the board of directors for the Homeowners Association for the two buildings that are on either side of the building in question. Like the Kildall building, the security warehouse is historically designated structure in the Minneapolis warehouse district, in this case built in 1902. Our association is committed to historic preservation and has spent more than $1 million to update the exterior of our building. So we were disturbed by the request for variances. Any discussion of the North Loop warehouse district needs to reflect that neither Security Warehouse nor its neighboring Kildall building were part of the originally designated district for which the boundaries were determined in 1978. The historic district was listed on the National Register of Historic Places in 1989, but it was not until 2009 that the city extended the original boundaries of the district, at which point both of our buildings became part of the district and had to comply with city and federal historic guidelines. Keep in mind that our building, and that was one that the applicant had shown, was developed in 2004, 5 years before we were designated as a historic area. That distinction matters because LTI has referenced these changes as a reason for them to be allowed to have changes as well. But Security Warehouse followed the 2004 city rules when it was developed, just as it has the 2018 ones, as we did improvements on the exterior of the building. Kildall, however, wants to ask for an exception for this. Even though the Minneapolis guidelines say the loading docks are an important part of the character of the district, and it's not appropriate to remove, lower, or narrow them. Now, LTI has also indicated that they want to move the stairs, and those stairs would be moved, for my understanding.
Oh,
Can I continue?
thank you. You can, about 30 seconds, and it would also help to say in support or against, just be very clear, that would be helpful.
We are against the appeal for the variance.
Great. Sharon, we have one question. Councilmember Goodman?
Ms. Dean, welcome. We've seen this issue before. I'm just interested in, so you didn't like the previous plan, you opposed that. Now it sounds like there's some conflict between your building and this building about that. So they've tried to do an alternative and now you oppose that.
I would say they're two very separate issues.
But it's the same. They have to figure out how to park this building inside. And so they came in with a plan and you guys didn't like that, but we unfortunately had to give them some leeway to do it so they could utilize the building. Now it sounds like they haven't been able to do that. Is that correct?
We are in litigation over the original issue that came up, which had, and I do need to clarify that the first time that we were here, your committee in the city approved the garage down below. They did not approve access to the garage. That was a separate issue.
But that's
And
now
what
the subject of an issue between two property owners and we have nothing to do with it.
No, I understand. I just wanted to clarify that.
But because of that, I'm sure if they were able to move forward on this side, they wouldn't probably be asking for something on the other side. So I just want to understand then, you don't want them to do the other side either, so that's kind of backing them into a corner to not be able to park their building.
I would say that we are, because we're in discussion about how that other property off of Washington is going to be used. Once again, it is something that's going to be decided hopefully in the next month or so when we, as we've been talking, we've had mediation over that and another hearing over that. I would say that the historic variance is an entirely separate issue. It is something that I think is critical to the neighborhood, to the sort of chipping away of what actually makes a historic district special in the eyes of.
Well, I understand
everything.
I understand how you see it. But I'm
Yeah.
just telling you how I see it, which
Sure,
looks
sure.
a little bit like we don't like this, but we also don't like that. And our job is to try to figure out how to give them a property right to be able to park their building. And if they can't do it one way, then perhaps it has to be another. For us to say no overall would seem to be us saying you can't put any parking in the underground portion of this building at all, because we're not going to let you access it in any direction.
I guess I would suggest that there is no official right to have a parking garage in the basement of your building, that there are times that perhaps other things overrule that. In this case, this is a very specific issue that's addressed by historic rules. For the other one, it has to do with, working out, two neighbors working out an easement. They're not, one isn't dependent on the other, I would say.
I guess I would think that, and I'm happy to ask the applicant that, if the litigation was resolved and they could put their access through the other side, they probably wouldn't be asking for this, but they can answer that question. If it was resolved to their satisfaction or mutually in a satisfactory way, they probably wouldn't be asking to have access on the other side. So it is intricately combined. And we can ask them that. I'm just trying to understand the situation.
Sure, I understand that. I guess I think that there are larger issues regarding the historic request for variances. One of them is that the stairway is proposed to be moved off the area that would be where the ramp would be, and moved on to the drawings were to have it moved on to Fifth Avenue itself. What we're which is a busy street, which is also where city parking is. What we are suggesting in the letter that I sent earlier is that in addition to the historic variances, that one of the things that you need to consider is that there is a lot of effort to make changes in a historic building when in fact the gain from this for parking places in the garage are very minimal. In order to make that change, for example, in the loading dock and move the stairs, the city's going to lose 2 parking spots that are on Fifth Avenue. The applicant is also going to lose 2 spots that are where the ramp would be. So we have a loss of 3 to 4 spots which means that the request is to make a whole lot of changes in historic variances for what amounts to only an addition of 16 parking spots in an area where, in a district where there is so much building that is going on, and much of it, including parking that would be available to the public. And so the question that we ask you, and which was addressed by the HPC earlier, is it justified to make a change in a historic nature for a very modest outcome that is not available to the public at any rate? What kind of chipping
Ms. Dean,
away?
I was simply asking about why you're trying to stop it on one side and now trying to stop it on the other. I understand you'd like us to think this is about how you view it, but we're supposed to judge both sides. And so I'm just trying to understand what's going on. And I clearly understand your point of view, and I read your letter, but it doesn't eliminate the fact that you don't want parking on one side, access on one side, and now you don't want it on the other. And we can make a determination of whether or not we think that that's legitimate or not. That was my question. You don't have to answer.
Okay.
No, thank you.
Okay.
I'm not debating you.
Okay.
I asked you a question.
Okay. Were there any other questions?
Any other questions? All right, thank you, Ms. Dean.
All right. Thank you.
Anyone else interested in speaking?
Thank you, Chair, Council members. My name is Jacob Steen with Larkin Hoffman Attorneys, 8300 Norman Center Drive, and we represent Modern Love Veterinary. That's the tenant, the business located in the subject building immediately adjacent to these proposed modifications. And it's the business that's most likely to be affected by these changes, and we strongly oppose the appeal. With respect to the certificate of appropriateness and the historic variance, we do agree with staff's recommendations and findings, and we agree with the HBC's 9-0 vote to deny this application. Removal and partial destruction of this loading dock is inconsistent with the district standards. A loading dock is a historic feature of this warehouse historic district and a historic feature of this street. And there are several explicit guidelines that require the preservation of these loading docks. Now, this appeal relies in large part on the assertion that these modifications are justified by existing loading docks that have been modified within the district. But I think that that position is unsupported by the district standards and unsupported by common sense. Damage to existing historic resources does not justify further damage to the remaining historic resources. Those remaining resources should be preserved, period. I also want to touch on safety concerns because I think there's a real safety concern, particularly getting to the two-way traffic on a less than 10-foot wide drive aisle. approval of the appeal is going to create a very unsafe condition, and that is a speed ramp that exits onto a public street in direct conflict with bicycle and pedestrian traffic. And this is going to be exacerbated by the fact that, again, it's less than 10 feet wide. There's no way to turn left or right. And the height of the loading dock blocks any views of vehicles coming in or out of the speed ramp. And this is going to further be exacerbated by the fact that the stairs are being rerouted from inside of the site to this blind conflict point. So this project is inconsistent with the Warehouse Historic District standards. It's unsafe, and we strongly encourage you to deny the appeal. Thank you.
Thank you. Is there anyone else interested in speaking? Anyone else interested in speaking? All right, this is the last call. And seeing no one, the hearing is now closed. See if there's any questions from council members. Otherwise, Councilmember Gordon?
So we've approved them to already build an alternative way to solve their parking problem, though? So they could they just go back and do that?
Staff?
Okay, I just want
Thank you, Chair Schrader. Councilmember Gordon, yes, their approvals were valid approximately a year ago. The decision period is for 2 years, and they can be granted an extension for their preservation approvals up to an additional year. They would be accessing via shared access easement. So as it's been alluded to earlier, there's some litigation around whether or not that shared access easement could actually provide access to what has been approved by the city so far.
Do we have any estimate on when that litigation will be resolved?
I think I heard that they're in mediation in a month and a half. Okay, middle of November, 2018.
Thank you, Councilmember Goodman.
Thank you, Mr. Chair. I'm interested in the city attorney's opinion with regard to where we're at on the 60-day rule. Do we have the ability to wait and see what the outcome of the mediation is? I don't want our decision to affect the outcome of litigation one way or the other. So I want to call out what I see is happening. So do we have the ability to delay this past that date to find out what happens with that?
The City of Minneapolis has granted the extension from 60 to 120 days, which is set to expire on November 27th. And that would have to include Zoning and Planning Committee, full council, mayoral signature, and publication.
And Mr. Chair, so should we not be able to meet that deadline? Are there other statutory requirements to extend the deadline another 30 days? Would the applicant have to approve? Is that not possible at all?
Chair Schrader, Councilmember Goodman, the applicant would have to willingly provide an extension to us. So it looks like, based on our current timeline, we would have the ability to act on this through the Zoning and Planning Committee November 8th at the latest, barring any further extension, again, voluntarily by the applicant.
If we could hear a little bit more on your thoughts on this.
Thank you. We are not in mediation. We went to mediation, that failed. So what's pending is a motion for summary judgment in the Hennepin County District Court. Pursuant to Supreme Court rules, all district court judges are supposed to issue an order within 90 days after taking it under consideration. That 90 days expires on or around November 17th. However, if the judge goes past 90 days, so it doesn't happen often, but it can, so there's no guarantee that it's going to be November 17th. Given what I would call rather contentious litigation and what's occurred to date, I can rest assured that there will almost certainly be an appeal no matter what happens at that on that decision, because somebody is going to win and somebody is going to lose. And based on what I see, we have an appeal. An appeal can go another year or a year and a half. And from there, whether or not it would end up getting taken up by the Minnesota Supreme Court or not, I mean, that could extend it even further. My point being to give this body its full information is we would not be able to, we most likely will not get a decision by that November 8th timeline. And even when the district court does make a ruling, there will almost definitely be another process in that litigation.
Thank you.
Thank you.
I think I'll just express my thoughts on this. It's very much a balance of wanting to preserve a historic district at some with very specific qualifications for that. And it's very frustrating to hear that the city tried to work out a deal on that and we're being stopped by litigation very successfully. And now that there's other option there, that is also being opposed. So it's really a matter, I think Councilmember Goodman put it best, like, how are we going to make this work? And it is just trying to figure that out. And it would be very helpful to have some suggestions from the neighbors what they'd like to see. But so far, just judging from the exchange we had, was pretty much no other options. If you'd want to come back to voting, I'd love to hear your thoughts on that.
There is another option, and that would be, this also has to do with Washington Avenue, and the matter under litigation is whether to use a shared access agreement that the parties have. But the owner of the building, the other building, Kildall, also has parking spots along the whole length of the building, which also could be a driveway into a parking garage. We're not opposed to the parking garage. We're fine with that. We are concerned about these other issues. So if the applicant wants to shift over the movement into the parking garage along their building, that would be another option.
Thank you. Is that possible? Yeah. I'm just trying to get an unbiased, because unfortunately, what I very picked. Yeah, I know. I understand that very well.
In order to accommodate a new driveway here, we would have to extend this curb cut to be approximately 35, 40 feet along Washington Avenue. I believe we would be challenged in having such a wide curb cut in such a very important pedestrian and bicycle heavy transportation corridor. Additionally, we would have to see whether or not turning movements could be accommodated in that narrow space between the building and the existing property line. So at this point, staff believes that the findings are there for today's decision, and we have previously approved a project that we felt as though was more appropriate for location for accessing underground parking.
Thank you. Council President Bender.
Before you leave, could you show us just one last time on this image, or perhaps on the picture, the difference between the two options, even though it's not quite
Sure.
as simple as that?
Because it was a former application, it's not in my presentation today. I'm going to see if I have it in the previous packet. Sorry.
Mr. Chair, if I may, while staff is looking for the images from the last approval, I would just say I'm sympathetic to the argument that we not, kind of go above and beyond to accommodate parking in an historic district in downtown, where we really are, through all of our policies, encouraging people to use alternative modes of transportation. The county is invested in a really great bicycle infrastructure. There's transit routes, a pedestrian landscape. That said, I think it's helpful to understand the difference between these two options and how feasible the one that is under litigation really is.
Thanks, Councilmember Goodman.
The one that's under litigation is feasible, and we approved it, but it involves the neighbors cooperating with a cross easement, which they're not willing to do, as a way to stop them from putting parking spaces in a building that already has them, by the way, in the basement, which is 16. I'll also note that despite some of our objections, the parking situation is so bad in the North Loop that we're letting Ned Abdul build like a 1,000-car garage. So, I mean, which I don't think was a great idea, but that happened anyway. So there is a pressing parking problem in this location, and they have 16 spaces in their basement, and we shouldn't be telling them, no, you can't use them because you can't access it. I would prefer the other option too, but the neighbors don't. They're litigating it. So we have to then acknowledge that as a reality.
Here is a side-by-side on your screens. On the left-hand side is today's proposal. On the right-hand side is the proposal that was approved last year. So you see cars would access the shared access easement. This heavy dark line shows the existing property line, and they would enter the garage on this facade. I can show you kind of the door. There we are. So this is what the facade would appear if you were looking perpendicular towards the new door. And this is a rendering of what it would look like from Washington Avenue. So you see that we were going to be getting some landscaping and screening improvements here. What would be visible from Washington Avenue was the ramp, or what would be the barriers as you're entering the ramp and traversing down towards the underground parking garage. Was that what you were looking for? Okay, great.
I think one thing, I'm very frustrated that the city worked on a solution that seemed like it would work and now is being stopped by litigation. It's a better solution than what's before us today. So I don't know if there's any thought on what could happen with the litigation with the parties both here. I mean, it's very much, it's turning into a no-win situation very quickly. Sure. I don't like having debate in the chambers, but yeah, why don't you go and then the applicant. We're putting a very brief time limit on this, yep.
Okay, I'll watch for a signal. The reason that the litigation is going on is because we have a very busy parking lot. This is part of the issue. It has to do with safety. It has to do with the amount of vehicles that are coming in and out. The area that the ramp, the entrance to.
Sorry to interrupt you.
I'm sorry.
Just to be helpful is what would change it? Like, we understand why you're in litigation. We understand why there's problems.
How
and
would
why,
that change?
How would it change, or what's the stumbling block? What would make an agreement with the old project? What are you looking for?
I would say we would be looking for an area that is not going to cause traffic issues for the people who live right there.
Okay, all right. So I'm basically, what I'm hearing is the other option is not an option for you either.
If they can come up with a variation of it that doesn't affect the historic variance, that's fine with us. But once again, when you're looking at the safety issues as well as the historic variance, it's a significant issue. And if they were to put the photo up again of where those stairs would have to be moved in the loading dock, it goes right into traffic.
Okay, thank you.
Okay.
Yep, thanks.
I can assure the city that if we were not stopped by the litigation, we would have gone with the initial one. This is costing us a tremendous amount of money, not outside of the litigation, but to do this. Because we have to create a rise over run, we have to create a retaining wall. There's one contractor in the Midwest that can put in that retaining wall. And as the city knows, when you have one contractor that can do something, you get a little unbalanced bid, if you will. So we would love nothing more than to go with that first proposal. And we tried Councilmember Goodman asked us to go and try to work it out. If you remember the last appeal, we went to the full city council. We tried to work it out. It failed there. We tried to work it out with a third-party mediator. It failed there. We don't have any proposal from the association as to what would allow that first proposal to go. So If we could make that work, we would. But you're correct. We do need the cooperation of the homeowners association, and we have none. This is our only other feasible way to accomplish parking down in the basement. And again, Councilmember Goodman is correct. There are 16 existing spaces, but we're going to be able to create 21 spaces of parking down below this building and alleviate the parking problem that the city currently has in this district.
Thank you. And thank you both for indulging the committee, too, with the extra time. Councilmember Reich?
This might be a question for staff. I think I might know the answer, but just for the record. Site plan review includes several different departments in PDR. This would have been the first proposal, the one that we approved. In its approval process, it would have went through PDR, and Public Works would have reviewed it. Did they raise any flags that this would be an untenable, unsafe, inappropriate from an engineering perspective arrangement between the two parking lots and the joint access? I'm assuming not. Otherwise, you wouldn't have recommended it.
For the first project, there were really no alterations to the public right-of-way, and there was no need to require a preliminary plan review or site plan review that would be before Public Works for review. The quantity of traffic is approximately what's there right now, because they are eliminating some of the parking stalls adjacent to the building to accommodate the door in this first example. And so the net increase in parking, if you will, assuming that people are coming and going, was maybe at most 20 stalls at the most.
So the claims of unsafe conditions being created is more subjective and not engineering technical in its perspective.
I would say that's correct, because again, we're between two private property owners. I can comment about the second proposal, however, that Public Works did express concerns with today's proposal. And that was, again, related to how the sidewalk terminates, the retaining wall, the height of the retaining wall, and really the width of the driveway being very difficult to maneuver. And it really, if you look at where the property line is shown and where the proposed driveway is, it's because there's another shared access easement off of Fifth Avenue. And that's, so their original proposal showed more than sufficient room for a driveway and seemed like a workable situation. But here again, we have a shared access easement that they cannot violate. And so the wall is right on the line.
So one more way in which we've concluded that we made the right decision the first time.
Councilmember Goodman?
Thank you, Mr. Chair. I am going to move to grant the appeal to allow the project to move forward. The reason we have variances is to take up situations where they are untenable. There are exceptions to rules. They should have agreed to something on the other side, but to hold them hostage to not being able to use their parking makes no sense to me. This has been through a number of iterations where the parties have been fighting with each other, and unfortunately, we have to make a decision. And I think it would be untenable to suggest that they shouldn't use their basement for parking because of the issues addressed. If you should be able to resolve it in litigation, go to the other side, that would be great, but we're not going to be used as a body to get involved in litigation or to otherwise shut down their ability to put parking in their basement, at least not from where I sit. And I don't ask staff to draft findings of fact to support the council's decision.
Anyone else? I'd also support that. I have a lot of frustration. I would very much like to go with the other option, but the fact that it's being held up and that, again, this kind of body is being put in the middle is not how the city's time should be used, frankly. So with all that, all those in favor of Councilmember Goodman's motion to, that would be the grant the appeal of the denial. All those in favor say aye. Aye. All those opposed say no. The ayes have it, and that motion carries. Seeing no further business before us, we are adjourned.